Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? Off-label promotions and kickback claims can lead to civil and criminal investigations and lawsuits for life sciences companies. With the U.S. Department of Justice's ongoing interest in combating fraud, employers should prioritize minimizing exposure to key TAM allegations and whistleblower retaliation claims. On this episode of We Get Work, we discuss the situations that have led to FCA claims against life sciences companies. Our hosts today are Brett Anders, Principal and Office Litigation Manager in the Berkeley Heights office and co-leader of the firm's Life Sciences Group, and Paul Kelly, a Principal and leader of the White Collar and Government Enforcement Service Group in the Boston office of Jackson Lewis. Brett's litigation practice focuses on representing employers in discrimination, wrongful discharge, and wage and hour cases. Paul was an assistant U.S. attorney in Boston for 10 years before focusing his practice on representing companies and individuals being investigated or prosecuted for serious criminal violations. Brett and Paul, the question on everyone's mind today is, how can life sciences companies protect themselves against FCA claims, and how does this impact my business?
Thank you for the introduction, Alicia. Paul and I are happy to be here to talk about the False Claims Act and the types of claims we are seeing being brought against life science companies and, more importantly, how to avoid those claims in the first place. So, to kick this off, let's first get some general background on the False Claims Act. Paul, what exactly is the False Claims Act?
Thanks, Brett. The False Claims Act it's the federal law that imposes liability on persons or companies that defraud government programs. It's really the primary tool that the government uses to combat fraud against it. This law also includes a provision which is known as the key TAM provision, which allows people who are not government agents, called relators, to file and possibly pursue actions on behalf of the government. It's this provision that enables whistleblowers to file actions and, if successful, to recover a portion of any damages that are ultimately recovered. The vast majority of False Claims Act cases that have been filed over the past 5 to 10 years have been actually initiated by whistleblowers, north of 70%. These claims, we see them most typically in healthcare, life sciences, military and defense, and other government spending programs.
Now, in the life science area, what types of situations have you seen that have led to False Claims Act claims being brought against life science companies? You mentioned billing issues. Are there other types of issues that you have seen that have led to these FCA claims?
It takes various forms. Probably the most prominent is improper billing to Medicare or Medicaid, upcoding, inflated billing, misrepresentation of clinical information, resulting in unnecessary procedures or prescriptions and inflated costs being passed along to the government. But we see other areas as well. One area we see involves off-label marketing, which is false claims cases brought against manufacturers, pharmaceutical companies that are marketing drugs for a purpose other than that for which the drug has been approved by the FDA. And the problem arises when the off-label marketing leads to these prescriptions being filed and bills then being passed along again for payment by a government entity such as Medicare. And another area we see is false claims or misrepresentations to the Food and Drug Administration, which are referred to as fraud on the FDA type cases. And these essentially involve comments to the FDA regarding products which contain misrepresentations or other misstatements, and that these critical statements were perhaps made to the FDA in order to obtain regulatory approval for the new drug or the device, again, leading eventually to false claims for payment from the government in the form of reimbursements from Medicare or Medicaid. Another area we see involves like clinical trials for drug approvals. We see claims where there's falsification or manipulation of research data, or perhaps a failure to disclose obvious conflicts of interest in connection with certain research. And these are often brought forward by, whistleblowers as well. And then one final area that I'd mention is, we see these false claims coming up when you have the production of non-conforming products, which is effectively charging government reimbursement programs for prescriptions that are either ineffective or perhaps contaminated, which could not only be a violation of the False Claims Act, but could lead to potential criminal prosecution of the company or parties involved for violations of what's known as the Federal Food, Drug, and Cosmetic Act, which we at Jackson Lewis have direct and personal experience with.
Got it. Yeah, it reminds me, I was aware of one of these claims where it involved a life science company, and a employee was bringing in product from overseas. It was a product that they wanted to test and make a generic, and rather than go through the normal routine for bringing the product into the United States, they literally brought it in their carry-on case. And somebody in compliance heard about that. They complained, and eventually were terminated. And they were bringing a whistleblower claim because they were complaining about the manner in which this product was brought in, which they alleged violated various regulations on the import of pharmaceuticals. So you can see how there are wide-ranging areas and ways in which this law can be impacted. For those that bring claims under the FCA, what types of damages are available?
Yeah, so that's one of the things that companies and employers need to be really leery of, because there's an availability for what's known as treble or triple damages, 3 times the amount of the provable loss that the government has sustained as a result of the alleged conduct, plus recovery of attorney's fees and costs. There are also civil penalties that can be imposed against a company. And there's also an anti-retaliation provision, which allows these whistleblowers or relators to recover double damages plus their attorney's fees for any provable act of retaliation against them for having reported the fraud to the government. So, this law has some real teeth to it. And just by way of example, on the last point of these relators, again, one of the big incentives here for these whistleblowers to come forward and bring these claims is the opportunity to recover funds themselves. And the law allows for recovery of anywhere between 15 to 30% of the damages that are ultimately recovered by the government. And for example, just take a particular calendar year. In 2020, the government recovered about $2.2 billion from False Claims Act cases. And from that amount, key TAM whistleblowers received about $309 million, or roughly 15 or 20% of the total that was received by the government. So there's an incredible incentive here for whistleblowers and relators to bring these claims.
So it sounds like a person, if they're a relator, they can recover a percentage of what the government recovers. So they're not bringing the claim themselves. It's the government prosecuting the claim, and then they get a piece of the recovery. But separate and apart from that, if one of these whistleblowers themselves is retaliated against, they then can bring their own independent cause of action for whatever damages they experience, whether it be lost pay and the like.
That's correct. There are a variety of damage provisions, which makes this law very potent. There are very specific, unusual procedures associated with a relator bringing one of these claims. It has to file its claim under seal or in camera. It doesn't serve the defendant, it serves the government. It gives the government a period of time to decide whether the government wants to step in, intervene, and take on the prosecution, or whether or not it's going to decline. The government picks up anywhere from 20 to 30% of these cases, declines the rest. Most of the ones that the government declines actually get dismissed, but several of them get carried forward. The relator, even in instances where the government elects not to intervene, can carry forward and prosecute the case himself or herself and stands to recover a substantial sum if they're successful at the end of the road.
So, wow. So it sounds like one of the, issues I see is that these cases, start in secret almost. So the company may not even be aware that there's this claim. What are some of the other challenges or strategies for defending these types of claims?
Yeah, there are a number of issues associated with these claims. Intervention, obviously, by the government is a major issue for defendants, for companies, pharmaceutical companies, hospitals, medical providers, because now instead of dealing with an individual plaintiff, you're dealing with the incredible resources and investigative tools available to the government. This anti-retaliation provision has real teeth to it. Many companies, act precipitously, and then they discover that, someone has, blown the whistle or brought this forward to the government, and they immediately react in a way which is unfortunate. They terminate the employee or suspend the employee, and now they're facing significant problems. I mean, there are a number of defenses. Obviously, many of these claims are commenced in an improper manner. They filed a claim with the government agency instead of the way that you need to do it. There are standing issues. In other words, whistleblowers, have to have certain direct and independent knowledge. They can't have learned about certain facts from something in the in the media or a publication. So there's a host of those types of issues when these cases get filed initially. Companies really do need to take these False Claims Act cases very seriously. They're not something to take lightly. They need to, number one, encourage employees to bring concerns or complaints forward that they may have regarding medical procedures, billing practices, pharmaceutical approvals and the like. If they understand that there's a claim out there, they need to investigate it properly. They want to be transparent. If they discover that there's an overbilling issue or that they've received funds in excess of what they sought in terms of reimbursement, they want to bring that to the attention of the government. The worst thing that a company can do is to kind of turn a blind eye to these False Claims Act cases. They really do need to be taken very seriously right from the start.
Now, I know, Paul, you had the opportunity to take one of these matters through a trial. Are there any takeaways from that experience that you can share with us?
Yeah, so we have obviously had a company up here in New England that, again, brought forward by a number of whistleblowers who were employees of the company, were charged not only with False Claims Act violations, but with, violations of the Federal Food, Drug, and Cosmetic Act and other federal laws as well for doing two things primarily. One was sending out products to doctors and hospitals that turned out to be contaminated. Bacteria had gotten into some of the substances in the compounding facility in Massachusetts, and they were the types of drugs that were given to various patients that had spinal issues and caused enormous damage and heartbreak, leading to a number of deaths in a variety of places across the country and a number of very serious illnesses. So the other part of it was this company was alleged to be providing medications, narcotics, compounded narcotics, again, to hospitals, clinics, doctors' offices without corresponding prescriptions, which you have to have under the applicable laws. You can't just send drugs out willy-nilly and allow a doctor to, hand them out to people without proper prescriptions. Doctors and hospitals need to, request prescriptions and have those prescriptions filled, whether it's by a pharmacy or by a compounding. So we actually tried a case. Ultimately they indicted about 10 officials from this company, many of whom were pharmacists or other management employees. And the case was tried multiple times. The one portion of the trial that I was involved in actually went for 10 weeks. So these cases are very complicated. There were millions of pages of documents, which is a challenge for anybody that's trying these cases, enormously costly to the companies involved. So again, for employers and companies that are out there, you simply don't want to go down this road. It's why you want to have, clear policies in place. You want to have kind of redundancy. You want to have people who are checking your not only manufacturing processes, your billing practices. Be very cautious when you're dealing with substantial issues of potential fraud involving the government.
Yeah, it sounds like if a company is presented with one of these complaints, from a whistleblower before it gets to the stage of litigation, just an internal complaint, it sounds like it's something that the company really needs to take seriously. They want to investigate it, and they want to show that they welcome these types of complaints. They want people to come forward, and that they will investigate it and take appropriate action. So later down the road, they can start setting up defenses to claims that they were acting in a retaliatory manner. Any other suggestions on what companies can do to prevent these types of claims?
Yeah, I agree 100% with your points. I would add to that training is an important piece of this as well, and businesses in the life sciences sphere should require certainly new employees to be trained and certified, and perhaps regular retraining for employees that are involved in billing practices and things of that nature. I think companies and particularly healthcare entities need to have a plan in place to deal with any accusations of fraud, even frivolous ones, as to how those are going to be investigated and addressed. And I think you just need to have checks and balances in place. If you're sending out substantial invoices to the government for reimbursement under one or more government programs, you want to have those checked and rechecked to make sure that you're doing it accurately so that it doesn't come back to bite you later. So prevention is important, but I agree wholeheartedly with your notion that these are important claims. You do want to encourage your employees to be transparent. If they've got concerns, maybe you have a hotline in place or something, they should bring those forward to the company. The company wants to get the message across to the government that it takes these issues very seriously and addresses them promptly when they're brought to its attention.
All right, great. Thank you, Paul. And Paul and I would like to thank everybody. We hope you found the information informative and helpful. If you would like any further information about the topics we discussed, please feel free to reach out to Paul or me or the Jackson Lewis attorney with whom you normally work.
Thank you for joining us on We Get Work. Please tune in to our next program where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Google Podcasts, Libsyn, Pandora, SoundCloud, Spotify, Stitcher, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.